I want to continue talking about this situation where the individual has been offered a new position and it is a demotion, but there may be an obligation to stay in the demoted position. As I mentioned in the last video, that was based on the Mifsud case, which basically was in a death spiral after it was first determined in 1989. It looked like it was over and done. And then the Supreme Court of Canada, in a case called Evans, breathed new life into this concept. Now, Evans was not a constructive dismissal case, but what I'm about to say applies also to constructive dismissal cases. So what happened in Evans is Evans was the president of the Teamsters Union in the Yukon, and the union had an election, a new leader comes in, and Mr. Evans was told of his termination. So he retained a lawyer, and the lawyers were going back and forth negotiating a severance payment. It was not successful. And then the union said, you know, Evans, guess what? Why don't you come back to work? We're going to give you an extended notice period. Let's say it was 18 months. It might not have been. But come back to work for 18 months. Keep on working. At the end of that period, adios, amigo, you're done. Evans, quite naturally, was not too keen on this and said no. And he sued. And this case ultimately went to the Supreme Court of Canada. And to the astonishment of everyone on the planet, the Supreme Court of Canada said that if the continued employment is reflective of the same position or substantively same prestige of the position held, the salary is the same, and it's not demeaning, it's not acrimonious, then the employee should take the position through the notice period. So Evans lost his case. After Evans, this principle was further refined, and basically subsequent courts have said that we're going to apply a contextual analysis to the situation and see if the working conditions offered are demeaning, is there a stigma, is there a loss of dignity, and presuming the salary is the same. So this is viewed objectively. It's not based on what Mr. Evans would think, but what a reasonable person would think. And there are many cases that have allowed the employee to escape that obligation to work out the notice period, where the employee has shown that there's an atmosphere of hostility, embarrassment, humiliation in the extended offer of employment. And the compensation has to be the same. It must be concrete. The employer cannot require a release be signed, and the employer has to set the notice period correctly. Now, probably they should err on the side of generosity, but if they do not, if the employer says, okay, come back to work, you're fired, come back to work, here's 6 months working notice, and the employee's entitled to 15 months or 18, then the employee's going to be off the hook. He or she does not have to work out for that lesser time period. And so that's also going to be controversial. And as I say, this case breathed new life into Mifsud, which was dying a deserved death. And for these reasons, if you have been demoted or terminated and offered an extended working period, you got to get legal counsel and get up to date and make sure you get it right. Because if you get it wrong, you're going to lose your severance and you're going to lose the income you would have earned in the notice period that the employer has given you. So you got to be careful. There's a further issue that I'm going to discuss in the next video about the severance payments under the Employment Standards Act, which is going to add a new twist and wrinkle to this concept. But here it is. Be careful, beware, and be smart.